Welcome and thank you for joining us today on Level Up Law, where here at Legal Services, we are leveling up your legal knowledge on the different areas of law that we practice in. I'm Susan Ingalls, Senior Staff Attorney with South Carolina Legal Services, and I'll be the moderator of the webcast today. We are excited to be joined by Legal Services attorneys Jennifer Rainville and Elliott Tait. Both are experienced education law attorneys. Please note that this webinar is being recorded, and the recording and slides will be posted on our YouTube channel for South Carolina Legal Services later this week. We want to ask that you do keep in mind that this is general information for the public and not legal advice. You should always consult an attorney for any specific legal issues that you might have. And also at the conclusion of today's presentation, we'll provide information on how to apply for free legal assistance at South Carolina Legal Services. Jennifer and Elliott will be answering questions at the end of the presentation, so I do want to make sure that everyone knows we do Level Up Law every Tuesday at noon, and today's presentation is about education law. Next week, we will have a presentation about heirs, property, and probate, so always be sure and tune in. More about that at the end. During the presentation today, you'll all be in listen-only mode, but please do put questions in the question box. We definitely invite you to do that. We know there are a lot of questions on this subject, and now's the time to get some answers. Our presenters cannot answer questions specific to your situation, and there are some subject matters about going back to school during the pandemic that really aren't legal questions, but they'll let you know here at the beginning kind of what sort of questions they'll be able to answer. Again, thank you for joining us, and let's go ahead and dive right in. Jennifer and Elliott, you have.
Thank you, Susie. So that you couldn't see her face, but she is our lovely consumer unit head in Greenville, and she's been putting these together. So we thank Susie so much for her work. So I'm Elliott Tait. I'm the lead special education law attorney for South Carolina Legal Services. And I'm coming to you from our Charleston office. I'm joined by my good friend and colleague, I have to get this right, the lead discipline law attorney, Jennifer Rainville. Hey, Jennifer.
Hi, Elliott.
So it looks like you're coming to us from your home. Important to point that out because a lot of what we're talking about is kind of what we're all doing for school, virtual learning, and a lot of us are doing telecommuting, virtual work. Couple things, just like some disclaimers at the top before Jennifer starts us off with this presentation. So one is, Susie mentioned this, there's a lot of questions out there about the logistics of sending your kids back to school. A lot of those questions are not legal questions that have some kind of legal remedy or recourse. A lot of them are just district specific. So we just don't know. Every school district is doing it differently. How they're doing it down here in Charleston is different than how they're doing it in the Columbia area, in the upstate, all over, right? I mean, there's tons of districts and they're all doing it differently. So we don't really have answers for those kinds of questions. Also, there's not a lot of guidance on this stuff. There's a wide breadth of law that covers special ed, which we'll get into in this presentation. But the law is slow moving, and we haven't received a lot of clear guidance on what special ed and general ed, for that matter, law look like in COVID. So we have some good ideas. Jennifer and I participated in webinars talking with smart people all over the country about these kinds of things. So we've got some ideas for you, but also just understand that this is limited to what the law is, and understanding that we might not have specific answers to your questions. Also, because this is kind of an evolving thing, Jennifer and I are going to have probably different opinions and different takes on some of these things. Jennifer and I are good friends. Excuse me, we're good friends. Apparently I got emotional when I just thought about our friendship there. So we will be bantering back and forth. That's kind of our thing. It's done in love and respect. So you'll see some of that. And also you're gonna get a couple different opinions on what the law is here. And that's good, I think. Gives you a diverse set of ideas, but also just it highlights the fact that we're kind of all learning as we go, and we're doing the best we can. So, anything else, Jennifer, before you launch into this presentation?
No, I think you've covered just about everything.
Cool. Should we do a poll? Kenneth.
Oh, let's do a poll.
Kenneth, hit us up with a poll. So those of you that are participating on your computers, oh, there it is. You can click on one of these. So who are you? Are you a parent, guardian, relative of a student? Are you a student? Are you a school employee? Are you someone in the legal field? Or are you just like an interested member of the community? Oh, and it says organizers and panelists can't vote or don't vote. Okay, well, darn. So vote in that thing. Take 5 or 10 seconds just to take the temperature of who we are today. And we'll get the results here. Let's take another few seconds to vote.
So exciting.
Yay. We got some results yet? Okay. Yeah, 45%. Most of y'all, almost a majority of you guys, parent, guardian, relative of a student. Cool. Very cool. Got some school employees. Welcome. Welcome, school employees. Yeah, obviously you guys should understand that Jennifer and I come from a place where we represent students and families who are having issues with school districts. We sue school districts on behalf of clients. Obviously that doesn't mean that we're adversarial. It's a very collaborative process, and we're not collaborative people, but you guys are welcome, and we look forward to seeing your questions, and maybe even if y'all want to have some answers in the chat box. We're going to get to all that at the end. So if y'all have questions, type them in the chat box. You got things you want to say, chat box. We're going to keep them to the end. So without further ado, Jennifer, hit us.
All right. Today we're going to talk about, we've already told you who we are, and we're going to talk about different types of learning this year versus last year and what your rights are. So there are different back to school models this year, and I'm kind of spelling them out for everybody because I didn't know what they were until I looked them up and researched them. So the first one that we know of is face-to-face. That's traditional in-person learning. You go to class, and just like always, right? Schools can require face coverings be worn on school buses and in public school facilities. If your child has a medical condition that prohibits them from being able to wear a face mask, one of our pro tips here is that you call an IEP team meeting or a 504 meeting and make sure that that is listed on those documents. And remember, social distancing, all that stuff is going to be in place in the physical school setting. Anything, Elliott?
Yeah, the 504 and IEP stuff. So this is an important disclaimer because Jennifer and I are steeped in this kind of law. This area is like filled with acronyms and jargon. You can visit our website for more information about a 504 plan or an IEP if you're not familiar with those. I assume folks that are tuning in are most likely familiar with one of those two things. But yeah, those are legally significant documents. You can have attorneys present for developing those things, but you don't necessarily need to. So more information on our website should you need that.
And again, this is what we're talking about is that traditional sort of standards-based quality instruction that kids have been getting all along, but with those social distancing and other sort of restrictions in place. Then there's what we call a hybrid model, and that's where we're combining that face-to-face instruction and virtual learning on other days. So you might go every other day, like AB days, or Tuesdays and Thursdays, or whatever. Again, both the virtual instruction and the instruction that you're receiving in the classroom should be that standards-based education. It shouldn't be what you got in the spring of last year virtually. It should be standards-based. You're getting grades and all of that. So then there's something called virtual synchronous, which is instruction provided through a live virtual format using an online platform. So your teacher is going to be talking to you on your screen in real time, just like I'm talking to you right now in real time. And so it'll be that sort of learning platform. Again, it should be standards-based education, right? So you're going to get grades and it's going to be what you'd be receiving in the classroom, just delivered a little differently. So then there's virtual asynchronous, and that is basically a pre-recorded video or some sort of learning software that can be accessed at any time. So the advantages of that, right? Like a lot of students were already doing some of these web-based programs in the classroom. So, you know, there were math programs and things like that that students were accessing to sort of catch them up and stuff like that. So this is something that students should have been using in the past, right? But doesn't have that sort of live component to it. The other thing is that then there's flexibility in when exactly you're doing it, right? And again, still standards-based. This is not what we had in the spring. Okay, so how all parents and students felt last year about virtual learning. We were all very frustrated with it because, again, it was this logistical nightmare, right? There was no real instruction. They only had to provide a good faith effort to the greatest extent possible to educate our kids. And it was sort of one of those last minute things because it was an emergency. And services varied widely between districts, even districts that were touching each other, not just rural versus, you know, urban districts. I had some districts where special ed students were still getting their services, you know, in a video chat with their teacher, and others where they only got the software that they could participate in, which is hard sometimes. So what's different now? So what they called last year was the emergency deployment of continued learning opportunities. And that's a mouthful. And this year they're calling it a virtual instruction model. And so when we talk about last year, again, there wasn't real grading. They weren't taking attendance, so no one was being referred for truancy, that kind of stuff. It was very abrupt and unexpected. And it was just this sort of contingency plan. The difference is, and a lot of the times they weren't doing IEP meetings, they weren't amending IEP services. If you had an IEP meeting, the team was saying things like, we can't consider this information, that kind of stuff. Whereas this year, we're talking about standards-based instruction. Again, the content shouldn't be any different than face-to-face instruction that they've always been receiving. The only difference is sort of that delivery mode. And so we're talking, you know, they're saying they're gonna be taking attendance, right? There's gonna be dress codes in place, that kind of stuff. And again, how that stuff is all being done varies widely district to district.
If I could jump in, Jennifer.
Sure.
Number one, this little girl on this slide is so cute. Yeah.
She's adorable, right?
Number two, so we've seen in a lot of the publications from the State Department of Education, this term high quality education, emphasizing the provision of high quality, like you said, standard-based education. So I just wanted to jump in and provide some legal perspective, because I think a lot of parents, you know, some of the questions that we got ahead of time, parents that we've talked to before, you know, have questions about, you know, well, do I need this? Can we do this? Can the school do this? Can the school do that? From a legal perspective, here's what the school has to do. So our courts interpreting our state constitution have said that kids are entitled to, in this state, receive a minimally adequate education. So that's the standard for gen ed in our state. That's what our Supreme Court has held in our state, is minimally adequate. However, that doesn't really sound great. You know, so the State Department of Ed and school districts, you know, they don't like touting. You don't put that on a sign. Minimally adequate. You know, the school board, they don't run on the idea, I'm going to provide a minimally adequate education, because it doesn't sound great. And really, it's minimal. We don't have to get into what exactly the court held, what it is, but essentially you learn to speak and write English, learn some basics about civics and math and science, and that's it. You also, the school has to provide a safe environment. So when push comes to shove and the lawyers are involved and the courts are involved over, you know, whether or not your kid is getting the education that they deserve, the standard that no one wants to talk about, but as lawyers, we need to remind you, is minimally adequate. So we had a question about, actually a great question that kind of highlights this, is about, you know, a student not getting a tablet until December. And the question puts forth the idea that that would hinder learning. Yeah, I mean, it might hinder some learning. So, you know, I assume the question is, what can I do? You know, can I sue the school? What can I do to get that tablet into my child's hands sooner? The question ultimately for lawyers and for the court is that child without that tablet still getting a minimally adequate education? Are they learning to read, write, and speak English? Are they learning basic math and science? Are they learning basic civics? Are they in a safe environment? Minimally adequate again. So when push comes to shove on these things, for general education, now special ed is very different. We've got a lot of stuff that we can use in our arsenal as lawyers to help special ed students. But for general ed, as long as the school is providing minimally adequate education, you don't have a case. You don't have legal recourse. And we can maybe talk about other ideas. You know, the cool thing about school law is that it's there are a lot of things that you as parents can do at the civic and political level that's outside the scope of what we can do, right? Because I mean, you've got a school board, and typically school board members are not career politicians. They're just normal folks. So contacting school board members, going to school board meetings is a legitimate way to maybe get what you need that's outside of what a lawyer can do for you. So that's just one idea that I wanted to toss out, not to go down a deep rabbit hole on that, but sorry. Jennifer, continue forward.
All right, so next we're going to talk about your rights. And so what the State Department of Education keeps saying is this quality education. Content's got to be the same between the delivery formats. So just because I think parents were given some elections about which format they're going to, you know, that they want, you have to be able to be educated in that setting. Special education students are entitled to FAPE, which is Elliott?
Oh, thank you. Yeah, a free, appropriate public education.
Right. And so the other part of that is that they are also, as part of FAPE, they are supposed to be educated in what we call the least restrictive environment. And we'll talk a little bit about that going forward. But again, you need to be familiar with sort of what the reopening plan is for your school district. And remember that if your student is a student with disabilities, that they're a general education student sort of first, right? And there may be the necessary need or necessary need. There may be a need for academic recovery services for all students, not just necessarily special education students, because we lost a big chunk of time, and there's something called summer slide, right? Where kids at the end of the school year, when they come back in August, they've sort of forgotten the stuff that they learned at the end of the year. And so a good portion of kids are going to have even a bigger deficit because they were out longer. Okay. And so when we talk about a free and appropriate public education, we want to say that most students can receive a free and appropriate public education virtually. However, there are some kind of things that you can't do virtually. And so some of that would be like, you can't learn how to read Braille virtually, right? Like it requires some level of sort of in-person contact because you just simply can't learn that virtually. I mean, maybe you can, and I'm just not aware of it, but I don't think so.
I don't think so.
And so when we're talking about this, speech and language services, all of those other related services that your children were getting before, they should be receiving those now. They may look different, right? Because there's going to be some restrictions about mixing children from different cohorts and trying to sort of limit contact, right? So those services may look a little different, but they should still be being provided.
Oh yeah, sorry if you heard me take a deep breath.
I did. I was waiting.
You gonna say something?
Yep.
You're a good team member, Jennifer. Yeah. So again, this is just for special ed kids, right? So the standard free and appropriate public education is admittedly a higher standard than minimally adequate. So, and this is this is federal law. Whenever schools receive federal funding, and all of our public schools do, then the law regarding what's called the IDEA applies, and our state has also adopted those statutes in part. So this is for special ed kids. So if your child has an IEP or they need an IEP, this is your standard, right? So it continues forward. The two words that Jennifer and I have heard, practitioners in this area mentioned time and time again as we are implementing and developing IEPs in this time is flexibility and reasonableness, right? We got some questions about implementing IEPs in this time. And like Jennifer said, it's gonna look a little different. I think the question was something about a student gets 50 minutes of time in pull-out time, what we call pull-out time, going to the special ed classroom classically, right? Pre-COVID, 50 minutes, the special ed teacher comes and pulls her out, and you've got special instruction, let's say for math, right? In the current model in this district, I assume based on the question, like that's not happening. The pull-out time isn't happening. So what are your rights? You've got a legal document between the school and the parent. It's a federally enforceable contract that says 50 minutes, the child gets this kind of instruction. And Jennifer and I were talking about this question, and I liked her answer better than my answer. So Jennifer, I'd love for you to share yours.
The push-in?
Yeah.
Okay, so sometimes there's different types of delivery models, right? There's more than one way to educate a child, right? And so it may be that due to COVID restrictions, we're not pulling kids out, but we might be pushing in a special ed teacher, which means that the special ed teacher is providing the services in the classroom of the child with the general ed teacher. And that's something that some districts have been doing for a while, especially here in the Midlands. And so that may be what those services look like. So the minutes might change, right? And it might change what it actually looks like. But again, it's something that the IEP team needs to get together and meet on and develop a plan that's going to get your kid able to make progress towards those IEP goals, right? One of the other sort of disclaimers I will say with the free and appropriate public education, a parent can waive FAPE, right? But don't do that. Never do that. So some parents could say, I want my child to go virtually. The IEP team meets and they say, we don't think that we can provide those services virtually based on deficits, like we can't teach your child how to read Braille. And so if the parent says, I don't care, I want to waive that, they certainly can. But we would discourage parents from waiving FAPE ever. So I would encourage you to talk to somebody before you do something like that.
I've been surprised to find out that even pre-COVID, telemedicine has been implemented by a number of healthcare providers. So like speech therapists and even physical therapists, they have been doing telemedicine for years before COVID. So if your child has speech therapy or physical therapy on their IEP, it's not an okay answer for the school to say, well, I mean, come on, it's COVID, so we can't be doing that. You know, we can't do telemedicine. Yeah, it is possible. It can be implemented. It might require a few weeks to set up, but you know, part of maybe what Jennifer and I can help with is there are areas that you can push on and there are areas that you kind of have to give on. You know, something like getting telemedicine for these related services like therapy, like speech therapy, physical therapy. I don't know that if occupational therapy is doing it. I know at the beginning of the pandemic, we heard that occupational therapists were not officially doing telemedicine. I don't know if that's changed. A lot of people have changed their practices during the pandemic, but this is an area that you can push in on. Getting those services via telemedicine to make sure that your kid's still getting the services that the IEP requires them to get.
Right, in rural counties, if you're in rural South Carolina, it's likely that your child was receiving virtual speech language because there weren't enough speech language pathologists in those rural areas.
Exactly.
All right, so when we talk about the least restrictive environment, what we are talking about, again, first choice for students should be that students are educated, special education students are educated with their general education peers. And so they should remove students from general education only if the nature or severity of their disability is such that education in the general education setting with the use of supplementary aids and services cannot be achieved satisfactorily. So we want kids to participate as much as possible with their non-disabled peers.
Yeah, this is like an important hallmark of special ed law in the States, is that this concept of least restrictive environment, what we call LRE, another acronym for you to learn. Yeah, it's a hallmark that kids are best with the normal gen ed classroom with their non-disabled students. And then if you want to start walking that back, you've got to have good reasons for it. So the way that I typically think about it is, you know, on one end of the spectrum, you've got the gen ed classroom. On the other end of the spectrum, you've got homebound services where the student is at home and has no peer interaction, right? So there are lots of steps that you get to before that. And each time you take a step back from the gen ed classroom, you've got to have a legitimate reason to do that. So it's an important thing that it's a sword and a shield. I'll tell you, as attorneys for students, you know, a lot of times parents might want to say, well, I want my child to stay home with me, and I want to get all the services at home because I think that's best for them. Well, that might butt up against the least restrictive environment. If you don't have a good, legitimate reason for keeping them in the most restrictive environment, then the school can elect to file a case against you to force you to bring the kid to school. That's a legitimate thing that a school can do. It's happened before in some of our cases. So it's an important concept. Again, it's one of the hallmarks of our public education system.
Okay, so the next thing that we want to talk about is evaluations. And so one of the problems that we saw a little bit last year was that special education evaluations that were sort of in progress in the spring just sort of stopped, right? And they were like, well, we can't do any of the testing, right? Or we can't observe the student. And so one of the things that I will say is that the State Department has said that you can observe them in their current setting, whatever that setting may be, and you may need to do additional observations in the future to sort of when those settings change. But that's the way they're receiving their education now, so it's likely that the services and supports that they're going to need may change. One of the other things that is, I think, important to note is that there will be students who have certain disabilities that will require evaluations before sort of engaging in virtual learning. Like, for example, students who are deaf or hard of hearing are going to need something called a functional listening assessment to make sure that what is being presented virtually, that they're able to hear and understand, so that they're able to sort of get from it what they need to. Anything, Elliott?
Oh no, Jennifer, that was good.
Okay. All right. So when we talk about IEP meetings, they're gonna look a little different. They can have them virtually or in person, right? I've always been a big proponent and always encouraged my clients to attend them in person, to not appear over the phone, right? Because there's a lot of subtle body language that happens in those IEP meetings. And I think it's important to go in person. Now, obviously, that's not necessarily a reality right now, but participating virtually, make sure that you can participate to the fullest ability possible. If you can attend with your video like we're doing, that would be great, but understanding that definitely this changes things. If you are doing these meetings virtually, I encourage you to ask for draft documents. Now, it's important to note that that's just a draft. That is not necessarily what the IEP team has decided in advance, right? It's a starting off point. Where are we going to start at? And so those documents, having them in advance, you can review them and know where the issues are, what you specifically want to discuss and what questions that you have, so that it can be a more focused and sort of targeted meeting. Because sitting in front of a computer or doing a web-based meeting for 3 hours is excruciating. So you're going to want to make sure that it's nice and targeted. And then also give the district a heads up on what your concerns are, right? When I go in with a parent to an IEP meeting, I always tell the attorney on the other side, here's what the parent's concerns are, right? So that those concerns can be properly addressed.
Yeah, they're you know, the pandemic has opened up this whole the virtual IEP meetings and the virtual hearings, you know, for attorneys, virtual everything. It's great because you don't have to travel and more people are more likely to participate. But then again, like Jennifer said, you miss a little bit because of the body language. It's not as collaborative as a feel, but it's what we got. So I'll say that. Also, you can have an attorney present for an IEP meeting. Jennifer and I do IEP meetings all the time. You also don't have to. You can bring an advocate. An advocate in certain cases is maybe even better suited because it's less antagonistic than having a lawyer there. You know, no one likes lawyers. I don't even like lawyers. So Jennifer and I think, are typically helpful in meetings, but sometimes they can get pretty antagonistic. So an advocate's also something available for you to hire or even to get for free through different organizations. So yeah, that's what I wanted to say about that. Bye.
I will also say that general education teachers are required for IEP meetings unless the parent waives them. Sometimes districts will pose it like, are you okay with, Ms. Smith leaving a little early? She's got a class and we don't have anybody to cover. I would say that your general education teacher needs to be there. And it also needs to be a general education teacher that knows your student and that, you know, can offer some valuable team feedback. Like if your kid can't, you know, is struggling with math, right? Then your PE teacher is probably not the best gen ed teacher to be at the IEP meeting. It needs to be somebody who's, you know, familiar with the deficit and how it impacts the general education curriculum.
Jennifer, I know you have a note about this, but maybe we could chat about when an IEP team is necessary and when it's not. Because, so essentially, like the starting point is whenever there's a change in placement, which is another lovely term of art, jargon for you. Whenever there's a change in placement, you've got to have a team meeting. So you've got to get all these folks together, you know, 4 or 5 people at least, and have this official meeting. But, you know, there's a lot of little subtle changes that the districts are doing to, you know, work on the fly to provide FAPE and provide services. So any thoughts about that?
Yeah, so if you can't waive you know, your parent can't consent to waive that annual meeting, right? You got to have the annual. But if you have to have a special review, you can waive having an actual physical meeting for that, right? If you discuss it with the school and they say, this is what we want to do, and you're like, I think that's a great idea, that's certainly something that you can consent to.
Cool.
Okay, so when we're talking about IEPs, some of those, you know, accommodations and modifications and service minutes, that's all potentially going to look pretty different. And something that we heard a lot in the spring was, we can't do that, we can't consider that. And so the State Department has told us that's no longer an acceptable response, right? We have to figure out a way to make sure that kids are getting that free and appropriate public education. And so the cool part about this is because it's individualized. It's very individual for each student. So what I need in the classroom is going to be very different than what Elliott needs in the classroom, right? And so that's what the team has. They have lots of tools. They can be creative here. And I've seen some really creative things put in IEPs before that you wouldn't maybe think of right off the bat, that have done wonders for children.
This is one of the things, I don't know if this is the same for you, Jennifer, this is one of the things that I most have to correct the district and teachers on, is the individualized part. Especially in a time like this, schools and districts can say, we have a blanket policy. We have an absolute policy. We do not do that. We do not do that. We cannot do that. We cannot do that. This has to be an individual decision made by the team. So a common thing that I have to help re-educate folks on is, you know, when you have an IEP meeting, you figure out what the kid needs to receive an appropriate education, to receive FAPE, and then you give him or her those services that are required to get them there. What you see a lot of schools doing is they say, well, okay, here's what little Johnny needs. Well, let's go to our little toolbox and see what we got in the little toolbox. So we got this, and we got this, and we got this, and we got this, and we got this. But we, you know, that's not the way to look at it. You know, just because you don't have it in your toolbox doesn't mean you can't go get it. If the kid needs it to get an appropriate education, then the district has to provide it one way or the other. And again, no blanket policies. When you start hearing, we can't do that, we can't consider that, our policy is, you start hearing absolutes, then red flags should go up. And make sure that you make the district make an individualized decision. Now, you know, they might say, oh, well, yeah, they might actually have a legitimate individualized reason for that. But just be aware of that response from the district.
Right, I agree with that wholeheartedly. Like, as soon as they start telling me we can't do that, I'm like, really? Say that again.
Say that from my recorder, just a little bit louder.
A little bit louder, and identify yourself by name, please. No, I'm just kidding.
Yeah.
So the next thing we're going to talk about is homebound services. And so homebound services have been around forever, right? And they're to be considered when a child has a medical condition and they can't access the learning. So there is sort of some requirements for that. You have to have a doctor's note with a physician's signature, and it has to be approved by the superintendent or their designee. This shouldn't just be used to get kids in a virtual option if the district's offering a virtual option, right? But, you know, with the medical homebound, it's typically for students who have a chronic medical condition, and it may be something like intermittent homebound. I can never say that right. And so that's, you know, when you have a recurring medical condition that maybe periodically might take you out of the general education learnings. And this is for sort of anyone, any student could have this that has a medical need. All right, so the next thing we're going to talk about is contingency plans. And you can have a contingency plan sort of built into place for what happens if there's an emergency school closure, right? What happens if your child gets exposed and has to quarantine? And so you can put all of those plans in advance, you know, down in your IEP, what it is that triggers those to happen. So that way there's sort of this seamless transition, or as seamless as you can get, right, between whatever model you choose and sort of your contingency plan, which is likely going to be like a virtual based instruction. All right, so parent tips. Address your concerns with the district in writing. Always put everything in writing and save that, you know, save those emails that you sent, all of that, because it may come into you, you may need it later, right? Don't waive your rights. Talk to an attorney before you waive your rights. And if you see a problem and you're not getting any results, right, by talking to the district, look into getting an attorney or an advocate or something like that involved in your case. The statute of limitations in filing a State Department complaint is very short. It's usually 1 year from the date of the event. So you don't have a whole lot of time. So you want to make sure that you're addressing these things early, because the longer that these problems go on, or problems that you have, it's likely that, you know, the child's behavior will escalate, or the further behind they will get. And so that's why it's important to address it early. And I will tell you that there's going to be some kinks, right, that need to be worked out. It's not going to flawlessly work, right, because that's not how life is. So again, be reasonable and get help quickly. Legal services, we have free attorneys. There's a special ed clinic at USC that also offers, you know, law students that can help on these cases. Protection and advocacy is also there. Anything you'd like to add, Elliott?
Well, I mean, maybe I'll save it to the end.
I think we're there.
Oh.
Well, I think we have to talk about comp ed, and that's it.
Yeah, sure.
Okay, so compensatory education services. We're talking about compensatory ed. Basically, if the school fails to provide your special education with a free and appropriate public education, or FAPE, then you may be entitled to some compensatory education services. It's designed to sort of close the gap between where the student would have been if services had been provided timely and where the student's at now. Districts were given additional funding for comp ed, and that's what we call it, as comp ed. So it's something that they're aware of and that they may have to provide. And you can be creative here, like iPads for everyone, right, Elliott?
Jennifer likes to make fun of me for that. Hey, I like to get my students iPads. Sure.
So again, you may be entitled to your student may be entitled to some compensatory ed for the stuff they missed out on in the spring.
Yeah. That's something that some districts might push back on because it's kind of expensive. And they might say that, I mean, come on, we couldn't, we did. I mean, it's true. It's not necessarily their fault that this all happened, but they've got a legal obligation to do it. And they've been told by the higher ups, folks that fund this, yeah, your excuses don't matter. You know, you've got, again, a federally enforceable contract in an IEP between you and the student. You got to give them, you know, damages because you didn't fulfill your obligation. Now, again, no one's blaming you for that, but still there are damages, and the damages are your kid didn't get the services they needed. So
Right.
we're going to get them the, what's that?
It's not personal.
No, it's not personal. But you might have to push on this, depending on your school district, you know. Again, be flexible and reasonable, but at the same time, you know, this is something that you can insist on. And this is something that a State Department of Education complaint could help with. If you're getting some pushback, again, like there's a 1-year statute of limitations. Some schools will delay until that 1 year is passed. And then once you're past that 1 year, you're dunsies. Like you've got I mean, you have the option of filing a different kind of lawsuit, but you'd have to get a lawyer for that, really, most likely. So one thing that I wanted to touch on was, so again, we got this really great question about, so here it is. My 5th grade child won't be going to the special ed room for pullout time of 50 minutes, kind of what we talked about earlier, Jennifer, right? How in the world can they meet their IEP? Which Jennifer mentioned the push-in time. And I guess to kind of piggyback on that and speak about it more generally is, think about the IEP goals, right? The IEP goals are the meat of the IEP. They determine what the school is actually going to do and where your child's going to be as a result of the service provided to them, right? So when you make that IEP, you look at year ahead and you say, okay, well, I think little Johnny should be here, right? That's the goal. Now, what happens in between is up to the school, right? That's their job. They're the experts on providing those services. So, you know, the 50 minutes of pullout time, it might look a little different, like Jennifer said. But again, the biggest issue, the question for the lawyers and the courts on this is, are they accomplishing their goal? Are they making reasonable efforts to accomplish the goal? So if they're being pulled out for 50 minutes of math help, are they getting that math help one way or the other? Is it the equivalent of 50 minutes? And again, most importantly, are they making steps advancing toward completion of the goal? I would say to parents, you are going to have to stay on the school as far as keeping track of progress throughout this time. The school is required to keep notes about progress.
Data drives everything.
Yes, data drives everything. That's a nice little soundbite, Jennifer. I love it. Yeah, I mean, if you need to have data, as I say, I guess, data, to prove where your kid is. And the school has to keep that data. They have to show it to you if you ask for it. And there should be periodic progress reports given to you. You're gonna have to stay on that more than ever right now, because we're being flexible about what the services look like. You just gotta monitor that. Be insistent on that. You know, make the school prove to you that little Johnny is in fact advancing towards his goals. Is he, you know, a quarter of the way through the school year? Is he a quarter of his way to hitting the goal? Now, you know, kids learning isn't that simple, right? You could have a breakthrough early or late, but you get what I'm saying. You're going to have to monitor this, demand the data, make them show you what they're doing, because there's less oversight and there's less structure. So the onus is, I think, on you, the parent. Jennifer, say something cool.
Susie, do we have any other questions?
Susie.
I'm back. Yes, we do have some other questions. One thing I wanted to mention that someone said in the question box was that occupational therapists can now provide teletherapy.
Thank you for that.
Yeah,
Awesome.
that's really interesting.
Whoever
and
said
then
that, thanks for that.
Yeah, I think the point y'all made about telemedicine is really crucial. Then someone asked about the term academic recovery. I think you may have mentioned academic recovery, and maybe you want to talk a little bit more about exactly what that is.
So I think probably what they're referring to is sort of the LEAP week that the schools are doing. And so that's again, that summer slide happens, that's real for all students, not just special education students. And that academic recovery is targeted at general education students to sort of get them back to where they were specifically. And so what that's going to look like, I don't know that they're real sure about how much our kids lost last year from being out. So it's super important that they are participating in those things and, making sure that they're not struggling this year. Because I think it's going to be really tough. Like, not only did they lose out on that instruction, they also lost out on the structure of the school day, right? And that's really going to be super hard for kids to get back in the swing of, right? Probably even more so than just typically being off for the summer.
Yeah, I don't know that, academic recovery is necessarily like a legally enforceable thing. It's just something that some school districts, I think, have been mentioning or doing to help catch gen ed kids up. So if you're a parent of a kid and you think, wow, like I would like some catch up time, reach out to your district. If they don't have a program, I mean, that's when you use your voice, you talk to your the members of your school district, the school board, and see about it. But again, I don't know that it's legally required. It's not like there's not a law requiring that.
Okay, can y'all talk about internet availability? There's a couple of questions from folks who don't have sufficient internet capability for the students in their home and are wondering kind of what, if any, rights they have in that regard.
So I think this one's a tough one, right? Because there are parts of the state that they just don't even have access to Wi-Fi. A lot of districts were purchasing up hotspots because not only like availability, but it's affordability too, right? Especially our clients, you can't always afford to pay for internet services. So there are some free programs that you can go through that we have shared links for before, but I think we can probably share them along with this video to sign up for. So that'll be something that we'll share when we post the video. But again, districts are purchasing up hotspots. So if that's a problem, you need to talk to your district and talk to them quickly, because I suspect that they will run out of those things very fast.
Yeah, I think probably the way that they get around any kind of legal issues there is, I mean, the schools have to offer in person, right? So if you don't have Wi-Fi, then you go in person. Is I guess how they would handle that. Now that's not. Go ahead. No, Jennifer, please.
I just don't know that that's if you have a child that needs virtual but parent can't afford it. I don't know that that's going to be the way that they can just throw their hands up and be like, we have in person. Sorry.
Yeah, well, that's nice. That's a nice idea. I don't know that I see all the districts being that nice about it. Yeah, again, I don't have a great answer for this. This is not really a legal question, but there's got to be some kind of equitable provision of services. And if you don't have a health reason to be home, and the governor said we got to have in person, I mean, I completely empathize with a family who doesn't want to send their kid to school, wants to use the virtual option, but because of funds or lack of access to Wi-Fi, because maybe where you live, you can't do that, so you're forced to the in-person. I don't like that option either. you know, this is one of those issues where I don't know that a lawyer can necessarily help you with that.
Well,
Unless
let's
you're
talk
Jennifer.
about Google Classroom. There's a couple of questions regarding taking attendance and teachers knowing if the student is participating. So can the teacher legally mark students absent if they fail to comment on Google Classroom? And second to that,
Yeah.
can a teacher take attendance by having the students type a comment instead of having them join a Google meeting or Google Classroom?
I laugh because isn't this just like an interesting question that no one would have ever anticipated? Yeah, so again, it's there's no legal, you know, can they legally do that? Sure. I mean, there's nothing that I am aware of that prevents them from taking attendance however the heck they want. You know, the laws about how this stuff kind of runs is not specific. It doesn't talk about how teachers can take attendance. I mean, there are laws about how records have to be, you know, true and accurate. But I mean, you know, if the teacher has a way of taking attendance and it seems reasonable to me, and you don't do what your teacher told you to do to be marked present, I mean, I don't see any legal recourse for that, unfortunately. Jennifer?
I think that they can take it. I mean, they obviously can take attendance, and they've said, you know, they're going to report people for truancy who aren't participating, and that's because they had so many students last year that they just lost track of, right? And so they can't have that happen again.
Yeah, if that's an issue, I mean, you have to be proactive with the teacher about it. If that's like a logistical thing that you can't do, then let the teacher know. If her way of doing it for whatever reason, I can't imagine why that wouldn't be fair and accurate. But if her doing that doesn't create a fair and accurate record, that's the only way that could be legally significant. But you need, you know, the courts aren't really, they're going to want you to work that out with the teacher first. You know, put that teacher on notice, work something out.
There's just a couple of comments. One individual mentions that their district is fully virtual, and then another says that some districts are not offering the in-person at all, which is, you know, essentially the same thing.
Yeah.
One question is, what if that medical homebound need is a mental issue?
That qualifies. Sure.
I'm sorry?
I think what Susie said was if the medical homebound need is a mental health related issue, of course, definitely. Yeah, that can definitely be a reason to get homebound services. Again, that when we're talking about the continuum of the least restrictive environment, that is all the way over on the side that we fight against. So you're going to have, you know, good medical reasons and a doctor on your side that agrees that that child cannot be in school. And there are lots of complicating mental health reasons for that. In fact, I think probably more often than not, we see them when they're mental health related instead of physical health related, at least in my practice.
I've had them both ways.
Yeah, but certainly I've seen both.
Okay, here's another one for you. My child needs a touchscreen laptop, but we were told we can't get one until December, and this hinders her learning. What do I do?
Yeah, we touched on that earlier. That's that question. I mean, again, the legal question is, can that child still get a minimally adequate education? So that we'd have to have more information on that. Why did I miss something in the news where I thought everyone had to provide in person? Are there districts that are opting out of the in-person thing?
I think that there are certain districts that, because of the rate of infection being so high and so many cases per capita, that they have only gone to a virtual only model. And I think that is allowed if it's like a hot spot area for cases. So there are districts who are doing that.
Yeah, I did not know that. I want to maybe change my answer with knowing that now, because it sounded like a couple of folks wanted to comment that. Yeah, I mean, if it's virtual only and you've got to have Wi-Fi and you don't have Wi-Fi because of many different reasons, either because it costs money or you don't have it in your neighborhood or something, you know, that is a district obligation. So they're going to have to do whatever they need to do to get that internet.
Agreed.
That's part of, I mean, even they can't, even we've been talking about minimally adequate. If you can't go, then I think that you're under the very low bar of minimally adequate. So I think you've got a case there.
Yeah, regarding the rate of cases, one individual asks, you know, I want my student to be going to school, but what if the daily cases do get really high? How do you make that change for your student?
Yeah, a lot of districts are requiring that parents who have a choice between virtual and in-person, that they choose that option for a specific period of time. Other districts don't have those rules because you can't keep pulling a kid in and out. You know, kids need consistency, that kind of stuff. And so we don't have a great answer for that other than to say, you know, in addition to what your school is doing, it's also a parental judgment, right? Like, what do I feel comfortable with? There are other options to public school. There are virtual academies that are through the charter schools that are free, right, for students. There are private schools. There are a variety of other kind of ways to be educated, and it doesn't have to necessarily be associated with public school district. In the sense of, you know, that traditional school district.
Well, Amy asks, my district is fully virtual and we live in an area without internet. We don't meet the federal poverty guidelines, so my children cannot receive a hotspot. What are my rights?
Man, Amy, yeah, that is, that's a conundrum for sure. I think that the school has to, if the school is virtual, then they have to do whatever is necessary to get your kids access to the curriculum virtually. You know, part of being in the public school system doesn't mean that you have to own a computer and have internet. That's just not where we are. That's not a requirement. If the school has elected to go virtual, they need to do what they have to do, whatever it is, to connect your kids with those services. And if that means that they have to pay a bunch of money, okay, then you insist that they do that. And if you get some pushback, then that's when you consider hiring an attorney.
Okay, just a few more questions at this point, and one is, if your child returns to school in person and then they get COVID-19 from being at school, is there any liability on the part of the school for that student contracting COVID-19? And I think related to that was a question that someone sent in saying, you know, what is the cost typically that it costs the school, one typical school, to disinfect their school daily, which I'm sure we don't really know, but I'm sure it's a pretty high cost.
Go ahead, Jennifer.
I will say first and foremost, we are not personal injury attorneys. That's not really what we do. And that's sort of what that first question is asking. I think it's going to be pretty hard to prove where you got COVID from. And I think causation is going to be one of those things that you're going to have to prove, like where you got it from. And because the rate of infection is so high in the community, I don't know the answer to that, but that would be my first thought, again, saying that I I'm not a personal injury lawyer, and they may have a very different answer for you. Elliott?
Yeah, the standard on these things is gross negligence, which is a high bar. You've got to prove gross negligence on the part of the school. That's a hard case to win for sure. And I think, again, Jennifer and I don't have experience trying any of those cases because we don't take those kind of cases at legal aid, but I can imagine that being a very difficult case to win, and a jury and or judge being pretty sympathetic to the difficulty of the governor saying, open up the schools. You got to open up the schools, and you got a bunch of dirty teenagers trying to hug on each other. Like that's kind of hard. So that, yeah, we don't have really great answers for that, but I think understanding the standard and the times that we're in, I don't know that you've got any real recourse in a court.
Yeah, that'd be a tough one for sure. One final question. I'm not sure if you've addressed this. Just asking, are there any special considerations if I want to put my child in something called an education pod or a pandemic pod?
Sorry, so just so everyone knows, so I have a child who just turned 1, and Jennifer has a child who just turned 20 something. So we don't have, I'm not as in tune to these things, maybe because that's kind of outside of the legal field. So Jennifer, have you heard about these things, and do you know?
Yeah, it's like, groups of parents who are getting together and putting their kids in, whether it's, I think some of them they're choosing like a homeschool option, and they're doing that in these, small groups because parents have to work, right? Like having somebody at home to supervise a kid who's attending school virtually that's a strain on a lot of people. And then other groups are putting their kids together to sort of just do the virtual learning all in one, like small area or whatever.
So what was the question?
It was just, are there any special considerations if you're going to place your child in that kind of environment or situation?
Gosh, I don't know. That's more like a medical question.
Yeah, I think it is. It's kind of what you want to do to protect your child in that situation that Jennifer just described.
Yeah. Don't know.
Well, I think that's all the questions we have. So I do want to thank you guys, Jennifer Rainville and Elliott Tait. What a terrific presentation today on going back to school during a pandemic. And let me thank all of you who were attending today and asking great questions. We really appreciate your interest in this subject matter and in the others that we have presented. Just to remind you, Level Up Law is a series of free legal webcasts to educate you on some of the most commonly faced legal challenges that we see here at Legal Aid. And you can join us every Tuesday at noon to learn the basics of whatever topic we are addressing that week. And of course, you can find this presentation today and all of our previous webcasts on our YouTube channel. Just go to YouTube and search SC Legal Services and click on our Level Up Law playlist. Just give us a day or two to get this particular webcast loaded up on our YouTube channel, and you can listen again. Now, you guys listen, if you have an issue, you need legal assistance, and you can't afford a lawyer, you might be eligible for our free legal representation. So we do want you to apply for help here at South Carolina Legal Services. You can see here on the screen our website and the number for our office in Columbia. If you're anywhere else in the state, you can call toll free 1-888-346-5592 between the hours of 9 and 6, Monday through Thursday. All of that information will be posted with this recording and all the other ones that are on that playlist. And just remember, our intake office personnel are standing by. We hope you'll give us a call and see what we can do to help you. You can also apply for our services online in addition to calling on the telephone. and that is at www.lawhelp.org/SC. And you can, of course, reach that by clicking on our website that's shown here on this slide. Located on that website are so many legal resources that are available to you. They include checklists, articles, brochures, videos, and even our online classrooms where you can learn about legal topics, anywhere from unemployment benefit appeals to filing for an order of protection in a domestic violence matter. Again, you guys here at Legal Services, we thank you for tuning in to Level Up Law, and we do hope that you'll tune in again next Tuesday when we'll be talking about heirs, property, and probate. Are you prepared? And backed by popular demand will be Jennifer Rainville, who was with us today, and Taylor Ott, who has been previously with us on a Level Up Law webcast back in June, I believe. An easy way to see what's coming up each week is to check our South Carolina Legal Services Facebook page. You can also follow us on Twitter and Instagram. So I encourage you to do that. There's all kinds of ways to get the information that you need. So again, thanks Jennifer and Elliott. That's going to conclude today's webinar, and we look forward to having you all back with us next week.
Thanks. Be sure to like and subscribe.
That's right, like and subscribe. We just reached over 500 subscribers last week on our YouTube channel, so that's really exciting for us. Definitely like and subscribe. Okay, thanks everybody. Have a good week.
Bye.